Hello, my name is Natalie Gregg, and I'm here with a podcast with the Honorable Suzanne Wooten. She is a former district judge. She has her law license since probably 30 years ago, and she is Master Extraordinaire Mediator. She's here to talk with us about Zooming and mediation. Gone are the days where we have to be in one single place in real time and negotiating with a mediator in the room. And I would just like you to tell us, Suzanne, why is that?
Well, for one thing, COVID really changed the whole frontier quite a bit because of the fact that we couldn't be in person. But it has made, I think, things so much more flexible and comfortable that honestly, and we can talk about this in a minute, I've kept my settlement rates and they're about 5% higher when you're not physically in the same location all together.
And so for those of us out there, clients and lawyers alike who might not know or have experienced Zoom mediation in this context, number one, could you explain to clients what mediation is to begin with?
Sure. So mediation is an informal settlement process that can have a formal result. So the parties do, whether with their attorney or they can be representing themselves as well. They operate in separate rooms. Even if we were in person mediating, I still do not put people together. I don't care if they're best friends and they braid each other's hair. They're going to be great co-parents, like that happens very often. Or if they really hate each other's guts. It's never good, I think, to put people together. So I don't do joint sessions. But so the process is each party's in their own room, and basically I'm the neutral. I go back and forth trying to facilitate a settlement that they both can live with, not necessarily are thrilled with, because the world is not that F-word fair. So I try to negotiate something, and if we get an agreement, it's written into a binding settlement agreement called a mediated settlement agreement. The parties sign it, it's filed with the court. And then whatever order, whether it's a suit affecting parent-child relationship or a divorce, or I also do probate and civil and a variety of cases, whatever that final document is, has to reflect the terms of that agreement that everyone worked so hard for that day in mediation.
A lot of clients walk in their consult and they say, I want a mediation. And I explain to them that this is part of the process, but it's not the process. So in terms of when someone lands into your office or your virtual Zoom room, is that typically with an attorney?
I've not really kept those numbers, but generally speaking, most people do have counsel. Personally, it's easier for me as the mediator because although I've been a lawyer, and you were right, about 30 years, I can't give legal advice to either party since I'm the neutral. So it does tend to help me because then if they need guidance in that regard, they can ask their lawyer. I can't give it to them. But generally there are, most parties do come with an attorney.
And so typically in the process, would it be fair to say that there's a filing of a petition of some sort, divorce, suit affecting parent-child relationship in the family law context. And then there's a process of some sort of exchange of information called discovery. And then after that has been exchanged, we get to you.
Correct. Some people come early. I mean, I've had cases where we've mediated pre-filing the lawsuit. That can happen. That's usually though in a modification case where they've already kind of done the process before. They need to tweak some things in a new order. That is binding. I mean, we had a lot of question for a while, for years out there about whether or not you could do a pre-suit mediated settlement agreement that's binding. And our Supreme Court, I believe, please don't quote me on that, I'd have to look, but they are. You can do that pre-suit, I promise. But yes, if you come too early though in the process, it's usually not very productive because you haven't exchanged enough information, or honestly, you haven't tried out that possession schedule to see if it might work long term. It's harder on occasion to be too early in the process to try to settle.
And in our profession, a great and scary thing happened called COVID. And I don't know about you, but I remember exactly where I was when they announced that they were closing pretty much all the offices and we weren't going to go anywhere. So as divorce attorneys and family lawyers, we just said, oh, goody, we get to take up basket weaving. Or a new hobby, making bread. But it actually worked out, the whole practice of law, and everything went on as normal. But we all had to get used to the screen, being on film, being, on Zoom all the time. But it came with a huge silver lining. Would you agree?
I do agree. And I think in the beginning, so there's lots of different mediators, and we all try to work together as much as possible to keep standard forms and language and things like that, because it's very important that those agreements are binding and effective. And so we all want to help each other, because that's the goal, is to get these parties resolved. But when COVID happened, a lot of us just were scrambling. Oh my gosh, how do you Zoom? How do you do breakout rooms? How do we get people here? What do we do about lighting? What do we do about DocuSign? I mean, thankfully, electronic filing was already happening for final documents and settlement agreements.
Sure.
So that wasn't hard. That wasn't new to us. But for everybody else who didn't use Teams or any of those go-to-meetings like some people do in their business, it was a little harder for us to figure out, oh my gosh. Plus, we had to see each other on the screen and go, oh, that's what I look like. That's the expression I make. Oh my gosh. So a lot of it had to do with, how do we put your camera in the right place? What kind of lighting, attire, make sure your camera's secure, because I had a number of people in the beginning where the camera would kind of fall. And although I appreciate that they wore pants, can I up here? My eyes are up here. If they could move their camera up. So I actually in the beginning did a little video about how to be a little more prepared for sound and lighting and just how you're sitting and what you're doing to try to help people so they're more comfortable. Because this hadn't been a normal situation of talking through a video and microphone.
Sure. And that learning curve was quite steep. I heard from some of the judges at CLEs that clothes were important to wear during hearings, during a Zoom hearing.
Yes, and mediation. So my confirmation letter typically says, feel free to dress comfortably, which is fine, because it can be 8 hours, it can be 10 hours, it can be a very long day. But there were some people that did take it a little too far. I had one person who shall remain nameless, lawyer, who may have been laying in bed in a T-shirt, and I thought, that's a little awkward. I had certainly parties who thought they weren't on camera and might have been in their tighty-whities getting covered up, that I just had to pretend like I saw nothing. People walking in behind people, not realizing they were on camera. I had one lady who was very, very kind, but she decided to put her makeup on while she was in the restroom sitting on the toilet. Thankfully, she wasn't actually using the restroom, but it was still very awkward that she was putting on her makeup. Again, she was very sweet. We just said, would you like a little break? Or you look great. So can we just go back to your dining room table, please?
So other than the hot mic situation that we might have, could you tell some of the clients out there that are contemplating, should I really do a Zoom mediation versus in person? What's better? What's actually the optimal environment?
Sure. And in the beginning, there was a lot of resistance. After things kind of got better and people were getting vaccinated and understanding how to distance and try to be careful, there was a lot of people still really trying to push in person to come back to that, because that's what we were used to. We'd done it for so many years, although we're all tired of Jason's Deli, although my husband did cook for all my people at mediation. I think that there still was this resistance, thinking we need to go back to the old ways because it's more effective. I disagree. As I said, I kept my numbers, and I honestly believe, because I watch their faces, and honestly with Zoom, with the cameras, I can see them a little better than if we're sitting in conference rooms, or I might be looking down, and because I can see all of the images on the screen at the same time. And you pick up on those facial cues if someone's uncomfortable, or maybe they're feeling pressured, or maybe they're not understanding. So I think from my perspective, it's much better for me to pick up on those cues. But just from the comfort level of the parties, the fact that you're not physically in the same location as the person who maybe you have family violence allegations, or maybe you just have verbal abuse or financial abuse. We hear a lot about that. People controlling.
Sure.
Controlling is a big deal. The fact that the other party can't just walk in the room, because I don't have armed security guards at my office. Most lawyers don't. I mean, yes, they do. They all do. But no, we don't. That I think that level of comfort has helped people to actually take a deep breath, be relaxed, really think through things, knowing they're not going to bump into whoever in the hall or the parking lot. I mean,
Sure.
People could be begging them to come back, or you never know. I think that the pressure is lessened when you're not physically in the same location. Everybody, the whole group together.
Well, I think there's also a lot of pressure to begin with. This is an expensive day. It's a long day. You're taking a whole day off of work typically. And you're focusing entirely on your conflict and hoping that at the end of the day, use the F word, that we're not going to get a fair result, but we're going to get something that both parties are comfortable walking away with and saying, I can live with that. So in terms of getting to the office being an obstacle and then running into the other party, this takes a lot of those logistic issues away.
It does. Honestly, the fact just the other day I had one of the lawyers was in Croatia mediating.
Wow.
And it was just fine. So if he hears this, I'm not going to say anything bad. I'm kidding. He's great. I've had parties like in the beginning of COVID who were stuck in Taiwan.
Wow.
And although the time change was rough for them for sure, we were able to still move their case forward and get resolution without waiting for things to open back up or for them to be able to clear to come back to the U.S. I've had parties in California, England, Brazil, you name it. They can be wherever they need to be and not have to lose work or spend money traveling. I mean, there's so many reasons, and not pay their lawyer to do lots of traveling either. If you have to go to that neutral location, somebody's going to have to drive, right?
Sure. And in the contracts, there's typically drive time and prep time. So in addition to just the logistics, with my clients, I typically ask that they come to my office to do the Zoom because I just want to make sure that they're fed, they're drinking water and coffee, and they're alert. And when we sign that really big signature line that says, I'm doing this voluntarily and I'm not under the influence, and I understand and had the advice of counsel that I've laid eyes on them.
Sure.
And I can emotionally support them.
And honestly, that's kind of how it's evolved more today, is that before we had to be in separate locations, absolutely. And then lawyers started having their clients be with them either in a conference room or in another room where they're still remote, but they're near each other, or sitting at a large table and working that way. It works great as long as everyone does their mic check and makes sure there's no feedback. But I also like when the lawyer can step out, because on occasion, there might be a topic that I need to just sort of address, like, hey, how do you want to bring up this topic? I don't want to blow things up, but it's important. Because my job is not to make people more upset or more angry after mediation. So it is nice when I have the ability to, like, when we mediate, I can text you, hey, can you step out? Can we chat for a second? Because I need the guidance of the lawyers. How do we address these with your clients? Because I don't want to blow things up. So as long as you have that ability, I think it's great when clients can be with them, especially since there are clients who are not technologically advanced, or that's not as common these days, or they have internet issues, or it could just be a variety of things. So you solve a lot of those problems and you're still physically together. Me being physically present doesn't really make a difference because I don't scream and yell at people and I don't beat them into submission. My motto is I pet the unrealistic. I don't fight the unrealistic. So for me, it doesn't make much of a difference if I'm not physically there. But I think it does help now that we've kind of evolved into this new process where people show up with their lawyer if they need to. Some still don't. Some still are at home with their pet cat or dog. And
sure,
I've scared cats before when I popped in a room. I'm back. I saw a cat flying through the room. But I think that the fact that we're still able to use this has really also freed up people to work. I mean, there are people who can't miss a lot of work. Maybe they've been in court a lot. Or honestly, I've had a lady who said, I've got to pick up kids. They're at daycare. Can I run for 30 minutes? Sure. I'll go back in the other room, go over some other topics. We've been able to be really adaptive with this process.
And I think some of the beauty of that hybrid is if you have someone who's running late or someone who has to pick up a kiddo or has a pet at home who's an old dog and they have to go to the restroom a lot. Right. I need to let Fido out. It's okay. You can do that. And you can also come for the bulk of it. And once you pick up your kiddos, you can excuse yourself so long as it's private and go into another room and we can resume it just like nothing happened.
Correct. You can call your client on the phone. You could text them not while they're driving. You can call them on the phone if I need to talk to you about an offer while they're in the process of whatever the errand is. I've had people can I run over to the bank and get copies of those records we've been missing? Absolutely. It's down the street. Go to Bank of America. I mean, we've really learned to be productive with the process within itself.
Do you see any downsides to Zoom mediation?
So I will tell you in the beginning, people, and every once in a while I hear it now, people will say, oh, you can't Zoom because people will just hang up. They'll just leave. You can't control them. Well, first off, I don't physically keep people in my office anyway. I'm not going to lock the doors and lock them in. So if someone wanted to walk out in an in-person, they could. I've only, knock on wood, I've had 2 instances. One where at the end, a party decided they didn't want to sign the MSA. We'd negotiated, it was all settled. They were reviewing the document in their lawyer's conference room and left. So the lawyer couldn't even keep them there. So they walked out. So it wasn't that they hung up. And then I had one person who just didn't like what their attorney was saying was, unfortunately, community property law in Texas, turned off their video because they were mostly a big giant baby. But they were there. So they didn't actually hang up. They were just having a tantrum and turned the video off. So other than that, I have not experienced some kind of easy exit or people acting tougher because they're on video. Actually, I think people are more mellow because they're not needing to be overheard down the hall or, make some weird front because their spouse might bump into them in the hallway. Honestly, I haven't seen much downside. Ms. Craig, have you seen much downside to Zoom mediation?
I have actually seen zero downside to Zoom mediation. What I do try to do to control as much as I can, the variables, right? So making sure that clients are at their best physically, that if they have to be, because if they're constantly diverting their attention to a computer screen or a cell phone or something else and they're not listening, then I want to be able to be the mom and just take it away. Sorry, you're grounded. Taking your device away. And then also just, I think it gives them such a great sense of security. So if I say you can come, you can literally show up in anything as long as it's decent. Clothing.
Covered.
Yes. Clothing is not optional, ladies and gentlemen. And just listen just like you would normally when we're here together.
Right.
But have a real conversation. And then sometimes also my clients love it, especially international travelers, consultants, people who really have time, so little free time. And this is, a career killer. Litigation can be a career killer just because we're in and out of court and it's not just an hour because it's not scheduled, right? It's on the court's docket, but whether the judge gets to it is a whole different situation. And so I just say plan your whole day, and they don't love that answer. But with mediation, I can say you're going to come in at 9, and more than likely you'll be done by 5 or 6. And yes, there's overtime, and I'll let you explain what that can entail and why we do that.
But yes, I agree with you that they definitely have more flexibility. Plus, as you mentioned earlier, that it's a very expensive day. They're paying the mediator. Now, granted, I'm the more affordable because I'm being shared between both parties, but their lawyer for all that time and prep time, because it's very helpful if lawyers, and I know you do this, do a pre-mediation meeting with their client to make sure, and you can talk about that in a minute, what you do, because I think it's great. Helps me too, because knowing that the clients are coming in prepared is fabulous. Overtime happens for lots of reasons. It could be a very complicated case that we just have a lot of details to go through, whether it's property or we're doing a really customized possession schedule because the beauty of mediation is we can really create whatever fits their needs best versus the cookie cutter of the courthouse or the family code that the courts have to follow because they take an oath to follow the law. So we can do, I can't say anything we want in the world, but a lot and customize it. And once that agreement is signed, it's binding on the judge too, not just the parties. So they have that closure and that certainty that the hard work is done. But I've totally forgotten your question. Sorry.
So at the end of the day, when the signatures are going out on DocuSign, so we were talking about typically, because I like to give a time frame. So people, I pretend like I'm the pilot and I explain, okay, there's going to be some turbulence. And then if you know there's going to be turbulence, though, you're not as scared, right? And when it happens, you're like, oh, that was planned-ish. And so you can handle it. And then at some point, we're going to take off. And at some point, we're going to land. And that grounds them, right? And so if I say typically, and this is just overgeneralization, but to help them with markers, we walk in, we get the intros for about an hour on each side. You get to hear all the sad stories.
Yes.
And
the cathartic part of the process, sure.
The background. And then also the rules of mediation. And you explain the rules again, hoping that the lawyer that they hired gave them the background of, I am a neutral. I am not here to give you legal advice. And, this is what this day is going to look like. But I say about 10:30, 11 o'clock, we'll look at some sort of a first offer. A little bit after lunch, we look at, a counter, hopefully. And then we're hopefully inking the document by 3:30, 4 o'clock. However, sometimes the flight does not go that way.
It's delayed. Well, actually, that was your question. Now I remembered. See, I'm not totally crazy. And it had to do with overtime. That yes, I typically, if I'm not typing if it's a full day, by about 4-ish, then I know we're going to go into overtime. Because though I do have a template ready to go before we get started, just so the basics are there, it takes time, especially if it's a very customized situation, which for me, I use a screen share all during the process that details, here's our offer, here's a counter offer. We highlight for everyone who's used it with me. I think it's awesome because then at the end, I cut out what we've agreed to, plug it into the settlement agreement, and then tweak it or beef it up, whatever we need to do. But we've looked at it all day. But if we're not drafting by 4 or 4:30-ish, we're going to go into overtime or we're not going to get it resolved. Normally, we know this is we're making progress, or someone's shutting down, or someone has now decided they're not going to agree. I mean, but that happens too at the end. Have you noticed that at the end, people are like, no, I'm not going to do this. I want that $2. Or something silly ends up getting in the way. And that's where okay, you could buy 6 more toasters instead of paying your lawyer for the argument over the toaster. So that's where I typically step back, big picture conversations. Hey, how much are we going to end up really spending? Is it worth it? What's your price of freedom? There's always a price of freedom. So it may not be as steep as one side wants, but if we're working, we'll keep going. And I'm happy to continue to work, but I will tell you, Natalie, you know this about me. I'm not a marathon mediator. We are not going to go till midnight, 2 in the morning. Number one, I can't do that. I'm just too old and tired. But beyond that, people stop thinking straight. Then they start giving into things that they would not have necessarily agreed to. And then who gets yelled at the next day?
The lawyer.
Yes. Why did you let me sign that?
That's what I love about you and the way you approach it is you call it when it needs to be called. And it's not a unilateral thing. It's just, hey guys, look, it's 8 p.m. No one is processing at full cylinders. So perhaps we reconvene, but we already have this document we've been working on all day. And while there might be 1 or 2 items of dispute, if you have skilled attorneys, would you agree that hopefully we can get them there maybe the next day, or if that next day we can't physically make that happen because of other engagements, we can resume, kick it back to you, because I just did this recently, and you made our edits and sent it back out in DocuSign, and everyone signed it by 5 p.m. the next day.
Absolutely. Whether it's come back for a couple of hours, I just had one the other day that we had it was an 8 or 9 hour session a couple of weeks ago. Then we came back over the weekend and put in a few extra hours to really get it finished. And we did, and it was fine. I'm always happy to do that. Or like you said, whether it's the attorneys still saying, hey, look, we've agreed on this child support number, or if you adjust this or take that tax language out or whatever it may be, we'll sign it. Then I do that early morning, evening, weekends, whenever I have a moment to do it. Absolutely. And we can still settle it, because my motto is it's not over till it's over, because up till eve of trial, you may call me and say, hey, we have a deal. Can you paper it? And let's get it signed so no one can change their mind tomorrow. Absolutely.
But one of the things that you were talking about earlier that really reminded me of why I do like the screen is that when you're looking at it, we're all visual, right? And especially when there's all these words, and our clients, they haven't seen these family code words and these fancy lawyer words, and they're just like, oh, my eyes are, crossing. But when they've been exposed to it all day and they've been staring at the screen in a good way, because I actually have my screen and then I have them have their separate screen. And when you're highlighting it and then calling to attention what has been changed, it's so much better than having a physical piece of paper and then going, did someone alter this? Is this real? Well, you're the master of the document and you're screen sharing. So we know no one has altered the document in any way. And there's more of a trust, I feel, that this is the integrity of the process.
So it's not that I'm a control freak, maybe, but it's really, yes, you're correct. Not only nobody has to read it 800 times, but I am the only person making the changes. So I do typically, as you know, okay, let's start. Here's the offer, type it on the screen, take it in the other room. Because there are times where you may tell me something that's not revealable. It might be strategy. It may be none of their business. It could be trigger stuff for the other side. And I put that in the back of my head. Okay, now I understand the motivation for this particular request. But I don't reveal it. I don't put those on the sheet. Obviously, the secret stuff's not typed. But then if I can go back and forth, and honestly, I learned this super early during Zoom, because when not only the stress of the whole thing, but if you have a case where one side says, sure, they can have expanded standard, You go to the other room, they say, okay, fine, which these are words like you're talking about that lawyers know, but the parties don't. Then I come back and they're like, we never agreed to that. We didn't offer that. That didn't happen. I never said expanded scenario. I'm like, oh my God, I wrote it down. Yes, you did. I'm not crazy. It's right here. And mediators' notes are confidential too, just like the process. So this really helped cut out any clarification issues or misunderstandings because I'd put, here's dad's offer, here's mom's offer. Joint managing conservator, sole managing conservator, okay, joint but this. And then as we're going, striking out, highlighting the colors so they can visually see the progress of the negotiations as well. I think that also helps them understand, especially when you get someone who wants to count concessions. Well, I gave up that and I gave up, wait, look on their side. Look what they agreed to. They gave up stuff too. You're both working here. Because some parties think I'm the only one working, I'm the only one giving. So I think that not only does that term sheet help, but then when I draft the mediated settlement agreement, letting everyone read it and then going, okay, let's talk about it. What are we changing? I highlight it yellow, go to the next room. What do you think? And I go back and forth. And at the end, look through it again, but you don't have to read it every single word over again because you just looked at it for the last hour or whatever it is.
Well, I think the same can be said also for spreadsheets. So when we're doing division of assets. The spreadsheet is, the almighty spreadsheet of here is our life on a piece of paper or two if you have a lot of assets or a lot of liabilities. You might have 3.
Sure.
But that spreadsheet we've been gazing at since probably 10 a.m. and it goes back and forth. And then as we have conversations, but I've noticed as a practitioner that my rate of having to go back and clarify or to come back for further orders on the MSA, the mediated settlement agreement, has really gone down from Zoom mediations because everything is already on that spreadsheet. And if it's a percentage versus a number, it's there in black and white. And so there's no question of what was tendered to the other party. Whereas I feel like in real time mediation in person, I think that was a lot more off the cuff in a way. And if we had sharing of documents, it wouldn't be an email of a document. They'd just take it into the room, right? So what was actually presented? We don't know because I don't know about you, but I have more than one case, right?
Right. No, I agree, especially with spreadsheets like you're talking about. I typically don't care whose spreadsheet. I'll make my own if I have to, but I prefer using one version if we can. Not only sharing it on screen, but it's amazing to me how many people, and maybe it isn't amazing, I have a minor in finance, so maybe that's why I understand a spreadsheet, that there are parties who don't really understand that on the spreadsheet, things are netted out at the bottom. And they'll say, why is this not 50 and this 50 and this 50? I'm like, well, we're offsetting things. And if I go through and highlight on screen, I can show them, see, look, here's the sum total down here. See, here's the sum. Here's that formula. This is what it's doing. Then they can actually physically see or visually see. Did that even make sense? Physically see? I hope so. They can see with their own eyes how it's actually calculating on the sheet instead of just looking at this piece of paper and going, I don't know how to interpret this. And then if they have a question, okay, look here, if we change that number here, look what it does to this. Now, if we do this, and that's where we also come up with good options of maybe a counter offer of, well, tweak this a little and add that. And look, the bottom line is what you were looking for because it's always about the bottom line, but they don't necessarily understand that if they haven't really been walked through the spreadsheet.
Sure. And in community property law in Texas, everyone wants to come in and say we have a 50-50. So I know a lot of clients throughout the process of Zoom mediation or real time or in-person mediation, we're looking at what is the percentage that I'm getting. But just mentally for practitioners out there, do you think that as we come away from the division that it's wiser to focus less on that division, that percentage number, and more on as you've educated your client and they know what's in the estate, and more on this is what the result is, and they feel like it's something they can live with.
I agree with you because you're right. If people are focused on that percentage at the bottom, people get really hung up on that. Why is she 49.176 and I'm 50? It doesn't matter. We need to really look at what's the nature of the assets and the debts because as you know, there's pre-tax assets and post-tax assets. And with interest rates so crazy right now, refinancing a mortgage may not be an option, but maybe somebody giving up a pension, which we have a hard time really accurately evaluating and valuing because you don't know how long someone's going to live, that being able to explain to the client, this is the lawyers, not me. I mean, we can talk through it. maybe this would be a more beneficial long-term asset for you than this. So maybe if you give up a little tiny bit here, it makes more sense in the long run, without them being able to see it on a spreadsheet sometimes, or even just however you add, show the calculation. They may not understand that getting hung up on that percentage isn't really as important as understanding what they're getting and what their future plan is. Because, most people are just scared. Oh my gosh, we're getting divorced. We no longer have a community estate, even if they kept separate accounts, which does not make it separate property. But we hear that all the time, don't we? But
Always.
we've kept it separate. But that fear of, oh my gosh, how am I going to pay these bills? How am I going to do this? Where am I going to live if I have to not keep the house, if I have to sell it? So helping them understand that there are these other options with the way you divide the assets and debts can give them some security, or at least a little more assurance that it is going to be okay, even though this is a terrible place in their life. And it is. It sucks. Divorce sucks.
But the lovely thing about you is that you're a fixer in a way, in that you come and help people come to the table and make a compromise and hopefully stop the bleeding and have some peace and hope.
I try because, like I said, my job is not to make it worse. But I also, from the perspective of having been on the bench, I know that judges see a tiny sliver of people's worlds. And there were times that I went home thinking, what did I miss? And I know I say this in mediation all the time because I want people to understand that if there's an asset that, because you don't have evidence, or you have a witness missing, or there's a discovery issue, or maybe it's a claim for abuse, or who knows what it could be, some allegation that the court doesn't hear, the judge can't go outside of the evidence. They go home, and like I said, I've had this happen, and think, somebody's not telling me, then they don't necessarily make the best decisions because they don't have all the information, which is why at mediation, we can discuss everything we need to talk about, whether it's admissible or not, or whether that witness, is going to show up. And so I appreciate that role of a judge is not that easy, and judges make mistakes. I mean, they do. They also just make people mad because that's not fair, or that's not what I wanted. I used to say 100% of the time, at least 50% of the people are not going to like what I ruled, which is true. But that's why you don't want that stranger in the black dress making your decisions for you if you can help it.
And so we'd rather have the stranger in the black and white jacket helping us.
She is wearing pants today, I promise.
She is. I can attest to that. Well, thank you so much for enlightening us on the benefits of Zoom mediation, as well as just mediation in general. And if you want to give the website that your mediation firm is with the 8 mediators that you have, I would really appreciate that.
Thank you. Yes, we can be found at NorthTexasLitigationSolutions.com. And as Natalie mentioned, we do have a team of 8 other former district judges, a former associate judge out of Dallas. We've got people who specialize in civil, family, probate. We kind of cover it. And we're all here to help. So our calendar is on the site, little bios about everybody. And unfortunately, between the 8 of us, we have something like over 280 years of legal experience. That does make me sad because we're old, but it's good. Solutions do come from experience. That's our motto, and I think that's true. So happy to see you, and we're here to help.
Thank you so much.
Thank you.